Thank you for joining us for 3Bs on the Law podcast, hosted by Trisha Barita, Camille Canali, and Susan Dawson. Disclaimer, this podcast is for entertainment and informational purposes only, not meant to provide legal advice, and does not create an attorney-client relationship. Also, remember, laws change or they differ by jurisdiction, so this is not a substitute for seeking legal counsel in your jurisdiction on the current law applicable to you. Well, hello, welcome back to 3Bs on the Law. Today, we're going to be talking about pay and confidentiality. Can an employer have a policy stopping an employee from telling another employee what he's getting paid or she's getting paid? So, what is the answer, ladies? Who's going to chime in here?
You cannot stop it.
The answer is no.
I think we all agree on this one.
Right.
You know what, though? I still get this question, but I mean, when you tell an employer this, company leader this, and they're not familiar with this law that we're about to talk about, that you can't let employees talk about their pay and try to keep that all confidential. The next question after that for them is like, well, why not? Why not? Why not? Because that's ridiculous. They shouldn't be able to talk about to other employees what they get paid. And I don't like that. And I don't, they all, it's very uncomfortable. Obviously, people are being paid different things. And so they don't want to talk about it. But the reason why not is because of something called the National Labor Relations Act, NLRA. And so we're going to kind of get into that just briefly here, sort of overview of what that is and why you should, know about it. And it affects everyone in every state. And usually when you hear the NLRA, people are thinking unions. And in my state, they just tune out because there's not as many unions as there are in other states. And so they think, well, I don't have any unions in my workforce. Why should I be concerned about that law? But guess what? The NLRA expands into that. So does anyone want to talk about what is the NLRA and its purpose? Susan, you got this?
Sure. Well, I tell a lot of same thing with my clients. I do have clients that have union employees, but I significantly more that do not. And you bring up the National Labor Relations Act, they're like, I don't have unions, and I'm like, yeah, it doesn't necessarily only apply to unions, right? It applies to all employers. So really, the NLRA is talking about whether or not employees can engage in concerted activity. That's the legal term, right? And that's mainly through unions, labor organizations, and all of that. But they're trying to put rules and laws into place to protect employees and to allow them to gather together and talk about workplace conditions. So that's where they come into play with things like whether or not you can talk about your salary. I mean, to me, that's it in a nutshell. What else do you think what did I cover? I mean, we talk about collective bargaining and all of that, but really where it comes down to controlling non-union employers, to me, is that protecting that concerted activity.
Right. The NLRA really prohibits both employers and unions from interfering with the employee's right to engage in the activities. And it's commonly referred to as Section 7 rights. That's super technical, but or otherwise restraining or coercing employees from engaging these activities. So essentially, you can't preclude employees from doing this. And most employers know that there are tons of websites now and apps that allow employees to share salaries.
Yeah.
There's Glassdoor, there's Fishbowl for lawyers, where you can compare salaries and see what people are making. So even if you think they're not talking about it, they are.
But they're still saying, like, we're having this conversation and I can still tell, like, there's employers on the phone going, but why not? Right. Why not? Why can't we prohibit it? Why is there a law against this? Because we should have the right to tell them to keep this confidential. And you know what I always say? I'm like, I get it. I totally get it. Like, that makes sense. And it does suck that they're going to share all their salaries and everything with each other. And not only can they share it and their salary, their hourly wage or whatever it is, they're protected. So like you can't have a policy against it, even if you would like to, because they consider it under this law to be a protection. So private sector employees are going to be subject to that, union or not, as long as, we're not talking about rail or air carriers, which have their own laws. But yeah, I mean, Camille's right. They're going to share it anyway. But as far as if an employee walks up to another employee, shares it right in the break room there, you know what I mean? And that's technically going to be protected under the NLRA. So you having these policies is against the NLRA. It's not, you can't even well, I'd like to say we would like for you to keep it confidential. You're actually violating the law right there. And that's how tricky this is and why so many employers have gotten in trouble for this very simple idea of, can you restrict employees from talking about their pay?
Right. And in these days of equal pay, employees are sharing because they want to make sure that they're making what Sally's making, who's doing the same job. And one of them may be making a little more because let's say one of them is just better at their job and more productive. So you need to make sure as an employer that you have some specific criteria for the salaries that you are giving.
And I think in this situation with NLRA, and I'm interested to hear your thoughts on this, Susan, too, but we've seen so much come out about this because this is such a, it's a hot topic in the employer world. We get that all the employers are not reading all about this, but this has been going up and down about how this was going to go and how the NLRA has handled so many different things related to handbook policies over the last decade. That a lot of my handbook has disclaimers that we're not trying to violate these rights. I don't know if that's what's in y'all's handbooks, but that's how crazy it's gotten these cases against the employers.
Right. Absolutely. No, you've got to have those disclaimers that in your confidentiality, right? If you're going to try to put some sort of confidentiality in particular, but those don't always protect you. So you can't just say, you can't say anything to the extent that we can stop you except under the NLRA, right? It's not going to be a catch-all, right? That's not what you're saying. Don't go put that just a disclaimer and think you're fine. You still have to be carefully crafted, but you do have to kind of have that safeguard there as well. I agree. I think that a lot of employers, especially small business employers, need to remember what it was like when they were an employee. It's hard. You can forget. But employees know a heck of a lot more and they talk a heck of a lot more than you think they do. So just be aware, right? This is something you can't stop them from doing. And be fair in how you're rolling out pay and be sure you can justify it. And if you're confused about some of that, go back to season 2 and season 3 of our podcast. We have plenty of podcasts that talk about exempt versus non-exempt employees and discrimination. But it brings all of that up.
Well, right. And not only can you not prohibit your employees from talking about their pay, but you can't retaliate against them if they do it. It could subject you to exposure.
Yeah. If they post on Facebook, I'm making this much to their other friend that they work with, that's going to be protected. I make $10 an hour and they tag, I'm going to use Susie or whatever. Susie.
You're always picking on poor Susie. Who is this Susie? I feel terrible for her.
Listen, I feel terrible for the worker making $10 an hour because you're definitely not living in Los Angeles.
Sure.
Oh, goodness. Okay. All right. But yeah, see, exactly. That's exactly what will happen on Facebook. I can't believe you're making $10 an hour. You should move to California. Yeah. Anyway, either way, be careful. Social media plays into that as well. What happens is I think it feels so, oh my God, I can't believe they just put that out there. That's such a, private part of our business. We've held that close to us, what we're paying people, and come to find out, when you start to do what Camille's talking about, retaliate against them, discipline them for that, fire them for that. You're walking down that road, making that case for you to get in trouble. And it won't take long, I got to tell you, because the plaintiff's lawyers on behalf of the employees, they're all well aware of this law. And so they hear a case where the employer had a policy or the employer fired you because you shared your wages. It will take them 2 seconds to figure out what to do with that case. So don't make that mistake. Just remember, you can't, even though you want to, you can't stop them from sharing this. So don't create policies around that. That's, I think, all that we kind of wanted to cover with that. Anything else, ladies?
I don't think so.
I think you did it.
All right. Well, thanks for joining us again on 3Bs on the Law.
Thank you for joining us on today's podcast of 3Bs on the Law. Don't forget to like and subscribe to our podcast. We also welcome any comments. If you'd like to get in touch with us or suggest a future topic, you can email us at 3THREEBsonthelaw@gmail.com. And because we're lawyers, we need to remind you that this podcast is not meant to provide you with legal advice and does not create an attorney-client relationship. Thank you again for joining us, and have a great day.